We'll get started in a couple of minutes with the final subcommittee members on her way upstairs, so give her a chance to get up.
So we're sitting in the different spot.
Good morning. I guess we'll start our first subcommittee meeting of the morning. This subcommittee is charged with looking at two bills. The first is HB 267, which is relative to criminal record checks in school employment. That'll be followed by HB 628, dealing with accepting public funds and background checks. So this subcommittee members include myself, Representative Cordiello, and Noble, Cornell, Tanner, and Ellison, but we don't have Cornell and Ellison, and instead we have, oh, I'm sorry. I couldn't see with the light behind you. So we do have Cornell and Tanner, and Representative Luno.
Happy to start.
So this bill was retained on a 10-10 vote earlier this year. It deals with the request originating in Goffstown to allow additional background checks to be done on a periodic basis. And I guess open it up for discussion first if anyone wants to comment on their recollection of the hearings and the focus of the bill. Anyone want to start the conversations? And I see we also have the prime sponsor here as well. Representative Tanner.
Thank you. Thank you. I understand and sympathize with the discussion that came in the hearing where some people had not had back criminal history checks for 10 years or so. But I also think that this is kind of too loosey-goosey, that that they may choose to require a criminal history records check in any group of employees on a more frequent occurring basis. I think that that whole statement needs to be tightened up to be more prescriptive than it is right now. I just can't support it the way it is.
Anyone else? Representative Luno.
Sure, thank you very much, Mr. Chair. And
So it wouldn't, so you're saying it shouldn't include a whole group of employees, but so,
yeah, rather than a group of employees, which is sort of a, I think a squishy type thing, like, I don't know what that group would be, you know, and do it on a basis that, that, you know, this employee had not been subject to a criminal background check when they were hired. And maybe it's that. Maybe that's the standard. I don't know.
I like the fact that it's a group that sort of maintains the anonymity. It's not necessarily for someone who hasn't had one, but to more frequently do it. And overall, this is just a permissive kind of bill. It allows you to do it. It's not requiring anything. So, as it's worded, I don't have. May. The employing school administrative unit may choose to require. That word may, instead of must require or whatever. So that's just my take on it. So just want to put that out there.
isn't this something that could be more local control, that if a district or a school department wants to negotiate it with their employees, they could put it into negotiations that they may require more frequent criminal background checks?
My recollection is that it might require something in statute to allow that also, to enable that. Representative Noble, anything off the top?
I mean, from what I remember, the group was included so that no one individual was being singled out.
Representative Alexander, would you be willing to come up and refresh our memories on some of the background and the purpose of the legislation, the intent, as we say?
Thank you for having me, this subcommittee. For the record, my name is Joe Alexander. I represent Goffstown. So just to refresh the memory of what the intent of this bill is, my superintendent was concerned that he is not allowed to, or during contract negotiations at some time, he may want more frequent background checks than the one in law that's required, I believe, by the DOE when you obtain a license, and the DOE is here. So all he wants to do is have legislation that would allow him to, during contract negotiations with a union, any union, doesn't matter who it is, allow him to put in to have more frequent background checks than just the one that they get. So that was really the intent of it. There's no requirement. He just wants to have that ability to include it in the negotiations. And that is all. So DOE is here, I believe, as well to give some information if you want to, what the background checks would include and things like that. So. And also the idea was to not single out any one employee. So yeah, like after after a union contract's approved, maybe everybody goes and gets background checks so that we're not singling out any one teacher, because that's not what we want to do. Sorry.
So that was the purpose of adding group into the proposal.
And I think Representative Luno, I think you have a good point, is that, you can put a year on it if you want. I mean, that we just want the intent of being able to have that ability to negotiate. So that's all.
Ms. Fenton from the department, if you'd be willing. Good morning.
So for the record, my name is Diana Fenton. I'm with the Department of Education, but I was also asked by the Department of Safety to fill in for them because they're all at a conference this week. I usually hesitate to speak on behalf of the Department of Safety, but I'm willing to do it today. But the caveat is, if I give any misinformation, I apologize ahead of time. I also asked the Department of Safety since I was speaking on their behalf, if I could have a hat and a badge and a cruiser, and I was denied. So I would just like to put
Not
that
even
on
the hat?
record. I didn't even get the hat, nothing. So, as the previous testimony was, this is not a bill brought on behalf of the Department of Education. We are aware of it, and I worked with the superintendent from Goffstown. My understanding of his thought process was just the ability to negotiate with the union to have some sort of routine background check. The reason it has to be in statute is because the FBI requires statutory language in order to disseminate the record to a school district. So that's the reason that it would have to be in law. And I have anecdotally over the years, I've had superintendents, truly a handful, no more than 5, express to me the concern of, someone's employed in the school district, they are subject to one background check, and then that's it. And I would like the ability to do that on a more routine, frequent basis. That's not a Department of Education issue, that's an employment issue. And that's kind of the reason it is before you. I do recall last year looking at the language, and Representative Luno, to your point, my concern looking at the language was that this not become a weapon that a superintendent can use to target one individual. I think in looking at the language, it's important to just make it applicable on a consistent basis. Pick a number, 3 years, 5 years, 10 years. That's up to this committee to decide that it is applicable across the board to a group. My concern in looking at the language would just be that it could be used to target a certain individual, which certainly I think would go against the intent of the underlying bill and the intent of this committee. So I just put that up there as kind of food for thought, if you will. And I'm happy to answer any questions. I appreciate the opportunity.
Representative Luna.
Thanks very much, Mr. Chair. Thanks very much, Ms. Fenton. Yeah, and good point. And I just to sort of clarify my earlier thoughts, I wasn't thinking necessarily specific individual, but specific individuals that have not had a criminal background check in a certain number of years.
Sure.
So rather than all teachers or all support staff or all select group that that has some other identifying factor, that the identifying factor or the qualifying factor would be have not completed a criminal background check in the last 10 years, 20 years, 30 years, whatever that qualifying factor is. But question is, what are other states doing with respect to this type of situation?
It's hard for me to represent all states. I think that in New Hampshire, the focus was always heavily on employment. The background check historically was a function of employment. Now, as this committee is well aware, that is a function that is shared with the Department of Education upon licensure. I think with most states, it is divided. There is the background check upon licensure, and then there is that employment piece as well. I think historically, because we've had so many changes in this area of the law, I mean, RSA 18913A was dormant for many years. It was dormant. And this committee has undertaken a lot of time in looking at it, understanding it. I know Representative Tanner has put a lot of effort into that statute in particular, and really trying to identify the weak areas. I think what this bill does, and I don't think the language is quite there yet. I think there are some really big concerns with the language, but the idea behind it is empowering superintendents to have that conversation with the union to say, what is appropriate? What does this look like? Can we come to terms? And maybe one of the provisions is that for individuals who did not have a background check upon employment, and I think we can all agree that is concerning, they would be subject to it. And then you build in another provision which allows superintendents to have a conversation with the union to say, what does this look like? Can we come up with terms of 3 years, 5 years? Something like that. I'm happy to look at what other states are doing in this area, but I think you're going to find that it is a split. It is a balance between credentialing or licensure and employment.
Yes.
So thanks, Mr. Chair, and thank you very much, John. And I appreciate the clarification you've made between employment and credentialing, and that this section is related to employment, not
Absolutely.
not credentialing. But I want to direct a question to your comment about the language, and I was wondering if you could help interpret the language that's in there. May choose to require, that part, may choose to require on any group, whether that is language that would enable a school district to put that requirement into a collective bargaining agreement during a negotiation, or it would enable a school district to require criminal history checks, may choose to require criminal history checks on any group of employees, outside of the collective bargaining agreement, outside of the terms agreed to in a collective bargaining agreement.
I think the bill as written is too generalized. My concern, as I expressed earlier, is that it would be misapplied throughout the state. And you need to have that consistency. It has to be a little bit more explicit as to what this legislature's intent is. So if the intent is to allow superintendents to enter into negotiations to allow for more frequent background checks, then I think that's what needs to be stated. I think you have to have two provisions. One that says, if it is the consensus of this committee, the concern to address individuals who were not subject to a background check upon employment. That's concerning. I think we can all agree to that. That might be one provision. And then the second provision, and that's, I think, few and far individuals, right? This is going back a certain number of years. This is not thousands and thousands of people, maybe hundreds, but a lot of people are going into retirement. So we can address that concern. And then there's a different subsection that talks about allowing a superintendent, again, employment, explicitly employment, nothing to do with the department, having the superintendent have the ability to enter into a negotiation with the union to discuss if background checks will be done on a more frequent basis and put some timeframes in there, right? 3 years, 5 years, 10 years. You can give some structure to that. That will allow the dissemination of the record from the Department of Safety to the school district. So you take care of that piece of it. And then you allow that local control piece. As written, I think this language is concerning. That being said, I'm sure there's someone out there on the YouTube feed that is saying to me, yes, but Ms. Fenton, you wrote it. And that's probably true as well. And there are times where I look back at my work and go, well, that's not very good. As I've said to my boss when he doesn't like my work, I'm not a robot, Frank. Sometimes I write bad things. So I think I did help with this language. Honestly, as I sit here today, the language concerns me. I don't think it's ready for prime time, as this committee has said. And I think my biggest concern is if you give generic, general language, you get inconsistent results throughout the state. And that's what we see at the department level. And that is hard to get ahead of. And it's hard to claw that back. So I'm happy to I mean, obviously this committee is more than just Representative Luno, but I'm happy to try to craft some language which would address the concerns.
Could I ask, you mentioned the changes to the statute over the past few years. And I think one of those changes, if I'm not mistaken, was to allow looking, and I'm not sure if that covers the employment or the credentialing side of things, to look at offenses maybe where there was not a conviction.
Yes.
But, and also look at maybe convictions that were pleaded down to misdemeanor levels. Many employees, I'm sure, had a background check prior to those changes.
Yes.
So I would see maybe those circumstances also being changed or incorporated into this so that any new check was, or checks could be done in line with the current statute, so that we pick up those individuals who maybe have had a longer employment history as well. Your thoughts on that?
Yeah, I think that's a very valid point to raise, and I appreciate you reminding me of it. It is worth reminding this committee that less than 10 years ago, what was released for employment purposes from the Department of Safety was simply a letter And the letter simply stated the candidate, and I will just use Glenn Cordelli as an example. Glenn Cordelli applied to be a teacher at SAU 39. Mr. Cordelli does have a Section 5 violation, which is one of the disqualifying offenses, and cannot be hired, or he does not, and he can be hired. But there was no information as to what that offense might be, or how long ago it was, or what it looked like. I really called them the red light, green light letter, because that's what it was. It was the Department of Safety that would cull through an individual's record, and they would type out this letter. There was a case in which a gentleman was charged with very serious sexual offenses, felony level. For whatever reason, they were pled down to misdemeanors. He applied at a school district. Department of Safety typed out the letter that said he does not have a Section 5 violation, and he didn't. He didn't. He had some concerning things on his record, but he did not have a Section 5 violation. He was hired, he reoffended, and that's what was brought to this committee's attention. And that is what prompted the change in the law to shift that responsibility from the Department of Safety to the district itself, because it is the district that has the liability. Give that responsibility to the district and release more information. So you are correct. What was done 10, 15, 20 years ago is in stark contrast to the procedure we have in place today. And so what might have to be put in there is some language about grandfathering in individuals who might have some of those offenses that the district would look upon as troubling.
Right, I think that goes all the way back. There was I'm not sure if it was a study committee or a commission chaired by Senator Ward, where we got into that whole letter with a number of different groups involved in that. And I think that was really the start of what has happened since then in terms of tightening up the background check process, the criminal records check process.
This committee has put an enormous amount of time and effort into that area. And again, Representative Tanner did a lot of work on that. It's a difficult area. And perhaps, and I throw this out simply as a suggestion, perhaps the permissive language of allowing a superintendent to work with the union to say, we're going to have a background check every 3 years or every 5 years. And again, I'm just throwing out numbers. That background check is just limited to those disqualifying offenses, which would prohibit employment anywhere. And that way you take away perhaps a bit of that arbitrariness that could apply. And again, these are just simply suggestions as we kind of bat the ideas back and forth. But you want to put in some structure if this committee were to allow this bill to move forward, recognizing it will be a different bill. But you want to have that structure in there so that it doesn't get weaponized in the field.
Thank you. Representative Tanner.
I am having a couple of issues with this. One is that at one point in my career from the dinosaur age to now, I had several background checks because when we renewed our license with the State Department of Education, which was every 3 or 5 years, at one point a criminal history check was part of that requirement, and it was done through the Department of Education. With this bill, and you've mentioned it too, it could be hodgepodge across the state, number one. Number two, I also worked with negotiations in my own school district, and I just can't imagine negotiating criminal background checks when they're required and when they're not, who's going to pay for them, who's not. Because it seems like the state either has a compelling interest to provide criminal history checks to make sure that kids are safe as we can possibly make it in our schools across the state very uniformly, or you know, rather than it be a semi-political football and a negotiations thing. And it seems like, why should Goffstown all of a sudden have every 5 years required background checks, and Kearsarge maybe 10 years, and maybe, you know, and if you switch schools, if you were to be hired by two schools, where do you fit within that limit? And even though it is an employment issue, I'm sure at some point it would speak to credentialing if all of a sudden they came up with a Section 5. That all of a sudden there would be a flag down at the State Department of Education as far as credentials are concerned as well. Is that true?
That is accurate, yes. And in fact, the way the law is currently written, putting aside this bill that's in front of you for your consideration, my understanding is that if the employing school district reviews an individual's record upon employment and they find a Section 5 disqualifying offense, then yes, they are required to notify the Department of Education. The reason being is that the department's position is that the department does not want to license or credential an individual who is unemployable. That doesn't support the field, that doesn't support child safety. So you are correct that the law currently has written nothing to do with this proposed bill. Superintendents have an obligation to notify the department if there is an applicant with a Section 5 violation, yes.
Representative, could I just ask you if you're thinking along the lines that if we amend this with new language, that language should specify a required period for all school districts to do follow-up background checks outside of the contract negotiation process?
Yes, I was not opposed to getting background checks, criminal background history checks when you renewed your license. The big thing became the price of it, and the fact that particularly for a new teacher that gets that early renewal, you know, just like us when we're earning $100 a year, you know, the cost of a computer or even a tablet takes away from that so considerably, and teachers are drastically underpaid. So I would say that rather than leave it up to negotiations and leave it up to the superintendent, if it, in my opinion, if it were going to be something that the state really thought was important, that definitely Representative Luno's piece, that if somebody is employed and has not had a criminal history check, that is like a red flag, I think, and definitely I think we can all agree to that. But as far as the other ones are concerned, I think it's consistency across the state. I don't know how that goes with the Department of Safety or whatever. You'd have to do an awful lot.
Chairman Ladd.
Thank you. And while Diane's here, I have a question for her. But first, it appears to me that 267 as written could be used to target rather and do it through, as we might compare to the kids misbehaving on the play yard. You line them all up against the wall, or just the one that needs to be lined up against the wall that's causing the issue. So are we going to get around dealing directly with an individual by putting forth legislation that encompasses the whole state and all? My other issue is that if it's a negotiated agreement issue, and it is negotiated, let's say every 3 years or 4 years or 2 years, whatever that you put in it, is the time in which an employee criminal background check is required. But what about the new employee that just came in the year before and just had a criminal background check? Are they going to have another one the second year after employment? If it's not in conjunction with the timeline in the negotiated agreement? And who pays? And who pays for this? That's going to have to be a local issue. And the last thing, Diana, is this issue identified, or is there a path towards dealing with the issue of why you're having a criminal background check through the Code of Ethics. Does the Code of Ethics, for example, we know there's a number of disciplinary steps there. And we've also recommended in the past or discussed the possibility of a fourth step that's initial before all those other three steps. And Brian's here and he knows what I'm talking about. So, and lastly, is this coming forth from the Administrators Association, or is this then just a singular administrator in this state saying, here, I need this in order to get things done the way I like to do it in my district? So those are all questions, but I'd like to know, is there any relationship between the Code of Ethics and does the Code of Ethics, if there's something going on, is that going to be caught by the Code of Ethics and something can be done that avenue with an investigation?
So under the Code of Conduct, if an individual is arrested for one of those disqualifying offenses, they have an obligation to report that. And that's the only overlap on the criminal records piece and the Code of Conduct. To answer your other question, this bill was not brought forward on behalf of the Department of Education. It was brought forward by the Goffstown superintendent. And just anecdotally, as I testified before, I've had a very small number, less than 5 superintendents over the course of my tenure at the Department of Education just express an interest in the ability to conduct a background check on a more frequent basis. Truly a small number of people. I don't want to over-exaggerate that at all. But it is a discussion that is out there, but this is not, to my understanding, not brought on behalf of the Superintendent's Association. It's just a superintendent from Goffstown.
Representative Myler, I was wondering if you had any follow-up, because I think you were one of the first people in the hearing to raise the subject of collective bargaining.
Excuse my sunglasses, but I just had my eyes dilated, so I'm having a hard time seeing and focusing at this point in time. I think the issue of the inconsistency, clearly the issue of negotiating this at the local level has always been there. And so my concern has been, if we were to negotiate this at the local level, of the point that Ms. Fenton mentioned, the inconsistency that would be across the state, I think would be a problem. My sense is, particularly with the last comment that Ms. Fenton said, this has not really been that big of an issue other than within this particular school district. And so based upon what Representative Ladd just said, I don't see why we would pursue this from a state standpoint. And this should be dealt with on an issue-by-issue basis based upon whatever the behavior might be of a particular employee, particularly dealing with the code of conduct and et cetera. So that's kind of where I see this thing going. Thank you.
Thank you. Yes.
I guess I just have a question about cost. And on line 4 and 5, it says applicant for employment in any position. So to me, is that any position? Is that teachers, paras, cafeteria, everything? And if you're going to require it, are you requiring all these people to pay for it themselves? Or is the school district going to pay for it? Because in Manchester, if you're going to require the school district to pay for everybody to get a criminal check every so many years, that's an awful lot of money with 2,000 educators and then paras and then bus drivers and cafeteria people. And I'm not going to vote for downshifting costs to my school district for that amount of money. Or to paras who make $15 an hour to have to get a criminal background check every so often.
Is there a general sense on the committee that well, I guess Representative Myler even raised it, whether we need this legislation or not, or that's question number one. And two, if we feel that something is needed, do we want to work on some amending language and come back to review amending language at a future date.
I would just have one more question, that if a school district had found an employee that had not had a criminal background check, without this RSA, would they be able to require as a part of their employment at that particular time to get a criminal background check?
I don't believe they would. The reason being is that the law is clear that it's upon employment. And I think the second layer to that is that the Department of Safety would not be able to disseminate the federal record to the school district because they have to follow what the law says. And the federal background check can only be disseminated to another governmental entity in very limited circumstances. There has to be statutory language that allows for that release. I think it would be prohibited.
So if I'm a superintendent and I'm hiring, let's say, a custodial or cafeteria help, that sort of thing, and they have to get criminal background checks.
Yes.
Yes. So if somebody, their employment, their terms of employment are yearly, I would assume. They don't go under contract under, for example, like a teacher's contract that would be 2-3 years. I would assume, maybe I'm assuming wrongly, that a person that's employed by a school district is on a yearly basis. So they're technically, they don't get paid over the summer. So their employment ends at the end of the school year, or July 1st when the school year ends, and then their employment picks up in September. So technically, they're reemployed. And at that point, couldn't the superintendent require that they take a criminal background check rather than write a law that requires it? I mean, aren't they hiring them, and therefore, as their employer, they could require the criminal history check?
I will be honest with you, Representative Tanner. I am not involved in those contract negotiations in any way, shape, or form. It falls completely out of the purview of my job. I know very little about employment law. I know two things. I like being employed, and I don't like when I'm not employed. Please forgive the double negative. I really am not the person to speak to when it comes to employment law. I don't know what a staff person's contract looks like. I've never seen one. It's not what the department gets involved in. I don't believe that a custodian's contract ends in June and picks up again in September. But honestly, I really don't know. I've never heard of that. I've never received that inquiry from the field. I suppose that a superintendent could do that to say, well, you're reemployed in September and we are going to do a background check. I've never had that fact pattern come before me. I think that particular fact pattern of an individual who has been employed in the district for 20, 30 years prior to a background check, who was not subject to a background check, is a very small piece of the population. It's an important piece of the population, and I believe that this committee could address it and solve that issue, but it has to be very narrowly tailored to that particular issue. And I don't think the issue is with a custodian or a cafeteria worker. The concern, as expressed from the sponsor and the superintendent who is behind this, is that very small group of educators who have been in the field for a long time, who just were employed before the background check was required.
Representative Luna.
So I think what Representative Tanner brings up is an important point, though, that could actually have some bearing on the law as it's written right now. I'm also not quite sure why it wouldn't apply to custodians and other employees, because we know that students certainly get guidance and support and stuff from teachers, but also food service employees and custodians as well.
And it should be applicable to them as well. I want to be clear that is all employment, but I think the individual who brought this law forward, his focus, and again, I don't want to testify on his behalf, but I think what he expressed to this committee was his concern was more about the educator who had been employed for that long
Right,
period of
right.
time.
So
Not to say that it couldn't be.
right, right. But
Sure.
but going back to Representative Tanner's point on that, and you know, again, this is only, you know, from school board experience, not, but, you know, I was chair for 8 years and I've signed a lot of contracts. And teacher contracts go year to year is my understanding. So it's almost like you're, I mean, yeah, you're certainly compounding the number of years
Sure.
on there, but it's a year to year,
Right.
you know, contract. And how, at least it was in our district. And how does that, if I can sort of find it,
How does it comport with the law?
comport with the current law, when it talks about with a final offer of employment subject to successfully completed criminal history records check. If that offer of employment is indeed that contract that begins July 1st,
Yeah.
and ends June 30th, begins July 1st, if they hadn't completed a criminal background check in their history of employment, could the existing law provide the language that's necessary for a school board to say, hey, you know what? You know, these employees were hired prior
Right.
to the requirement.
I think that's an interesting interpretation of the law. I don't think that's how, I only play one on TV. I think that it's an interesting interpretation. I don't think that's how the field interprets it. I'd be kind of interested, Brian. Brian's,
Employees that had not been subject,
Understood. Again, it's an interesting interpretation. I don't know if the Department of Safety would feel comfortable releasing the record based upon that interpretation. This is where I'm limited as to how much I can speak on behalf of the Department of Safety. I've never heard that interpretation from the field as seeing it as kind of a year to year, now we have to run the record again. I think it's
record is yet run the record first.
correct.
So
I'm here on behalf of Department of Safety, but not really. I don't know if that would pass muster for the federal regulations.
want something a little more.
Correct. The federal regulations, they're kind of, the Department of Safety works at their behest, right? And they're under very intense scrutiny from them.
Representative.
School districts, Diana, have a number of employees which are on stipend or coming in doing intramural activities or through contracted services with an agency of some kind. How would this change right here where we put into a negotiated agreement, for example, that every 2-3 years we're going to do this, work with the contracted employees that are coming in, those contracted teachers through the agency?
They would have to address that in their contract negotiations. I don't even know if it would really affect those contractors, those kind of short-term contract positions.
So we're contracting services for nursing in many school districts.
Absolutely, contracting
So-
services for a multitude of issues.
So obviously within that contract, the school board, the administrator is going to say, we want to make sure people coming in have that criminal background check.
Yes.
However, if we also have now by negotiated agreement, this issue, we're going to do it every 2 or 3 years, is how do we ensure that that employee that's coming or that person that's employed by the contracted service is going to be held to the same standard?
I would think that that contracted position would really fall outside of the purview of what is before this committee. I think what is before this committee is for those full-time, long-term employees of the district and the ability to negotiate with the union as to the opportunity to conduct a background check on a more frequent basis. And I think a school nurse coming in on a contract for a specified period of time would fall outside of that.
Thank you.
Any further questions for Ms. Fenton?
Yeah, kind of for her and kind of a comment. So I started teaching in '69, and I had to have criminal background checks. And I'm, up there in the years. I can't imagine that anybody's still teaching that didn't get a required background check in the first place. Because it never stopped. I mean, it was required a little bit more often for a while, but then it never stopped. So I find it hard, number one, to believe that there are teachers within the school district who are credentialed teachers who have not had a criminal background check. Okay, number one. And would that be pretty, do you agree with that reasoning?
Based on what you just said, yes, I would agree with that. I myself am not familiar with that amount of history. I can just talk about the past 10 years or so. But based on what you just presented, yes, I would agree with you.
And the other thing is that it seems like from our discussion that this bill is targeted only to those people who have a negotiated contract with a union. And from our discussion with Chairman Lab about the contracted services outside, talking about the janitors or the cafeteria workers. So really, the bill is targeted at people who are under negotiated contract. And in that case, really, putting those two things together, I feel as though this bill is totally unnecessary at this point. So,
Thank you. Quickly?
Oh, okay. So, I mean, this was brought forth because a superintendent felt the need for it. I'm thinking that, it's likely, it's not just that this idea was brought forth. There was obviously someone in a leadership position feeling some sort of need. So I do see some purpose. I always look for that, in legislation. What is the purpose? Now, you wrote this. My concern right now in voting for it is that there is a vagueness with this on a more frequent or recurring basis, that more frequent, like some sort of amending language where it would ensure that it wouldn't be, weaponized or targeting someone, because more frequent could mean every year. You want to have some sort of guardrails to it. So I'm thinking it's a good idea, but with some sort of amending language.
I'm sort of getting the sense that we're going to need a second subcommittee meeting. Getting the sense there might be some new language brought forward in terms of an amendment, but at the same time, some feeling that maybe the bill isn't required at all. Would the committee be in agreement that a second meeting is required?
From what Rep. Tiana said, if it started when she started in 1969, that means people would have been working now for 54 years. And I don't know how many educators are still out there that have been there for 54 years or more. So I don't know that we need to do this. For a handful of there could have been a teacher in Goffstown that the superintendent thinks but has been there more than 54 years and or they somehow slipped by without getting their criminal check. But, it doesn't seem like it's.
Could it maybe have a straw poll, just those who do not think that this bill is needed versus those who think that there should be some amending language and that we should look at that option. How many at this point think that the bill is not needed at all? And those that think there should be some amending language and that there is a need? So I guess we're funny about that, isn't it? Well, let's, since it is, the first motion in the House floor is always a positive one. So let's, have a second meeting and we can further discuss, the need and, maybe someone will bring forth some, maybe we can work on some amending language. And, we've had, an offer from, Ms. Fenton to help in that regard as well.
Can we find out the need for this bill? I mean, can we actually maybe find out?
I think there is a superintendent here. We didn't? No? Okay. All right.
So, and Mr. Chair, in addition to putting some, putting together some proposed new language as as Attorney Fenton has suggested that put some time frames on this, like whether it's every 5 years or every 10 years or has not been conducted in 10 years. So, wouldn't necessarily apply to every employee if they had one conducted 2 years ago when they were hired. Something like that, but also to make sure that this is a provision that could be negotiated into a collective bargaining agreement and not applied unilaterally by the school board outside of a collective bargaining agreement.
I think, as discussed, there could be 2 or 3 points to be made in an amendment as to the negotiations,
Right.
as you just said. There,
Right. I would just want to see, what that language, could look
Right.
like. The only criminal background check that can be unilaterally applied by the school board outside of a collective bargaining agreement is the initial during the application for hiring. And that's
right.
obviously very important because the prospective employee is not subject to a collective bargaining agreement at that point. And that includes the superintendent on down, so.
okay. So we will, Chairman Ladd.
I would encourage this subcommittee to come out with something other than a 3-3 vote on this thing. There are issues that have been brought up today. We've had the department indicate that the language as is stated in this bill right now is not right. We need to get something corrected there. It appears to me that it targets the way it is right now. I'm also concerned about a large district like Manchester might get into this business. What are those costs going to be for every employee thrown on them or on the individuals? If it's on the individual teachers, we already have a teacher shortage. Now we're going to just make it a little more costly for these teachers saying, I don't want to get into this business. I have to take the criminal background check when I'm in school to become a teacher. Upon getting out of it and going to student teaching, I have to take it when I get employed. And now I'm going to have another one here. That we're starting to chalk the money up here. And I think we got to be very cautious in that regard. And I've also like to have the subcommittee do a thorough check with the School Administrators Association and find out, is this a bill that's supported by them? Is it supported by the School Boards Association? And let's get a handle on this thing before we start changing state law to maybe impact a few. That there are ways which we can still deal with the few rather than having to put another statute in place. Thank you.
Thank you. So can we, not on a 3-3 basis, but can we agree on a subsequent meeting to further discuss this and possible amendments that might be brought forward? Okay. So we'll schedule another meeting, hopefully in conjunction with some of the other meetings that we have on our calendar. And we have one other bill that we have to take a look at, which is House Bill 628, requiring certain non-public schools or education service providers that accept public funds to perform background checks on all employees and volunteers. this one also, there was quite a bit of discussion and testimony, as I recall, and a number of issues raised again relating to employment and who has actually covered under the proposed legislation. Someone like to start the conversations, Representative Tanner?
I'm the prime sponsor. And when the bill was offered, I think one of the things that came to me that I would like to work on providing an amendment is that in no way did I mean or intend that a parent who homeschools their child in their own home would need to be receive or do a criminal history background check. That was not my intent, and I would like to expressly put that in the bill itself. But on the other hand, I do believe that we have to start making distinctions about children that are actually being educated under the EFA law and the Student Scholarship Organization receiving taxpayer resource funding through state funding, that it is a compelling interest of the state for the safety of children that people dealing with those children in a school setting be required to do criminal background checks. So that's the intent of the law.
We had someone that came in from a co-op that gave an example. If you have 6 parents teaching in that co-op, say there's 25 kids and just one of those kids is getting an EFA, are you thinking that they all need to get background checked now?
If that co-op accepts EFA money as tuition, then yes, they do have people hired or people that are volunteers on a regular basis for the children in that particular setting. Yes, I think so. I mean, it's the compelling interest of the state to have those children be safe.
I mean, it's in the interest of the parents as well for them to be safe, and they're choosing to be part of that co-op. So I don't see the issue of needing a background check. If they're choosing to be part of that co-op, these are people that they trust. Why the need for a background check?
There's trust and then verify. And I think that's, I know people that I thought I knew that were not as trustworthy in the end that I thought they were, and to the detriment of children. So, yeah,
Thank you very much, Mr. Chair. Yeah, parents make decisions to send their children to private daycare, and my understanding is that there's certain licensing requirements for licensed daycare providers as well. But and I'm not at all equating a homeschool education program to a licensed daycare. I'm not equating that at all. But my question actually is to Representative Tanner. In Section 5, which modifies the EFA law, are you suggesting that that all Amazon employees also submit to criminal background checks?
I mean, no.
No. So all right. So because the reason I'm asking that is I think the term education service provider is used broadly within 194F to refer to organizations ranging from home education programs all the way to, Amazon and Walmart. So, companies that are providing materials.
Right, may I respond to that?
Sure.
So my thought on that subparagraph 5 was that it was obviously Amazon and Walmart are supplying goods rather than services. And but Prager University or Prenda or Chi actually provide services where an individual is involved or several individuals are involved or software is involved that may collect data on students, where there would be a need for a safety net of some sort.
So follow up.
Yes.
So would, in order to line up with what you just said, and I agree with what you just said, would blah, 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 I don't know, paragraph D in section 5 have to have some language to qualify which education service, what types of education service providers would need to be subject to criminal history records check.
Yes, I think that's.
So we need some, change language there. Great.
Further discussion. Point out that I think in some regards, this legislation goes beyond what is required in public schools, especially in terms of volunteers. I think the statutes say designated volunteers, whereas this says basically all volunteers. So it goes beyond that we require in public schools. And also, in terms of education freedom accounts, the law currently says that education service providers that accept payments under the EFA statute are not an agent of the state or federal government. So I think we're stepping into territory that we shouldn't be in terms of putting those restrictions on them. And we've had testimony going back to the that background check study commission that I mentioned earlier, chaired by Senator Ward, where we had non-public schools, council, various groups coming in and testifying that they already do background checks. It's pretty much required for them in terms of insurance coverage that they do that. So I don't see a need for this legislation, and I think it goes beyond where we need to be. Representative Cordiello.
I do not see a need for this. I also think it may be harmful. It's somewhat related to a situation that I deal with at the public library where I work, where in order to just read a story at story time, to be a guest reader, you need to have a criminal background check. And I think that goes over the top. And what it does that I've seen, and not just story time, there was also a man who was very interested in helping children in a chess club. And I saw him just leave the library. I talked to him. He thought it was, ridiculous that he would have to have a criminal background check to help kids with playing chess when the parents are there. The librarian's there, and so that's gone to an extreme at the public libraries. But that's my background, so I just wanted to bring it up, that I see how that discourages volunteers from just coming to story time and reading a story to the children. And so I see this could go in that direction where it would discourage volunteers. There is also that issue of trust, which Representative Noble brought up. And again, in my current position, I've met a lot of homeschooling families in the town I work in, and they know each other. They work together. there's no need for this. So I am obviously against it.
Representative Tanner.
Maybe it's because I've had criminal background checks when I've had employment outside of schools, inside of schools, volunteering for different things, substitute teaching, driving a bus, that I'm not insulted by having a background check. I feel as though if I have nothing to hide, there's no reason for me not to comply with the background check. And I also feel that it is a safety net for kids. I mean, we've had kids that have just gone into who knows where, outer space. We've had numerous cases of kids that have been abused that are found at home. That I think that we should recognize that this is not an intrusion on people. This is a safety net for kids. And kids are being taught by, in Prenda, for example, an 18-year-old who has a CPR certification and may or may not be part of the community. And as I said before, there have been people that I know that have been part of the community that would be the last people I would suspect would be involved with child abuse and yet were. So I just see this as a compelling state interest.
You seem to be going back, though, into abuse at home, or it seems like you're going back toward the homeschooling situation. No?
I'm a little bit confused. There's a reference here to RSA 18913-A underneath number 4 here on the bill. And I'm looking at that statute right now under 193.13A Roman 1 Part B. A non-public school may elect to require a criminal history records check. Now, where it says in law that they may elect, and through an alternative program, I could receive funds through my savings account and have my student go for a class, let's say at a private school for 1 period a day. They're receiving instruction. But that private school, that non-public's not required to have that criminal background check. So where are we here? Are we now getting in the business where we're going to require the non-public schools to have criminal background checks when they, I'm just curious where we're going with this.
Representative Ludo?
Yeah, thanks very much. I don't want to get out over my skis here, but I think the section of the law that you just referenced, Representative Ladd, was in existence long before 194F came into being. So now we're seeing a situation in New Hampshire where taxpayer dollars are used to pay tuition bills for students that go to private schools. And I think, as Representative Tanner pointed out, there's a what's the term, a compelling state interest in assuring the safety of these kids when at those private institutions, and the state did not have a financial interest in it until 194F came into being. That all said, everybody in New Hampshire is a mandatory reporter. So if another adult, at a non-public school witnessed, a tuition student being abused, I think they'd have an obligation to any grown-up would have an obligation to report that. But yeah, this goes beyond it. If you're a non-public school taking state dollars now as a result of 194F, then then you would be subject to this new part in section 5, paragraph D.
I would just say that I think courts up to the Supreme Court have said that once those funds go into the account of a private family, they are no longer public funds. They are private funds at that point. And we just had a discussion on the previous bill about, if we get into compelling interest of the state, wouldn't it be a compelling interest to make sure that those employees in a school district did have an employment background check? So I think there's even more of a compelling interest, if we want to raise that argument, with the previous bill than this bill. Representative Tanner.
First of all, I think the referral to the 193.13 was also to say the designated volunteer, to indicate that's where the language about designated volunteer is. And I think that, the schools do, the reason we said the last bill was probably unnecessary was that even from the State Department, we heard that it is a very, 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 very rare circumstance where a person who is a teacher credentialed, it would be a mistake if it was a credentialed teacher that didn't have a background check. So I think that, and as far as whether it's public money or not, I think that's still a debatable question.
That similar to the original discussion of this bill, which ended in a 10-10 decision, that we're on a 3-3 course on this one as well at this point. Am I? Yeah. So I think that in that case, we would just go to the full committee when we vote in probably November, correct, Chairman Ladd? With the outcome of this subcommittee being split vote as well.
I have two questions on that. One is that, as I said, there are a couple of amendments I'd like to do on this, and would that be allowable at the time of the full committee vote?
I would think so, Chairman Ladd.
Amendments, or does that have to go in another subcommittee meeting?
Why don't we piggyback it with the other?
If you're coming back to do the other bill as a subcommittee, do it during the subcommittee and air your amendments there. So then we go to the final, because we're going to be running through 20 bills that day.
Okay,
So I'd advise you to do it as I think Representative Uno was going to suggest.
okay,
If you do want to offer an amendment, we will take that course then.
okay.
All right? So both bills, 267 and 628 will come back for a subsequent meeting to be scheduled in the near future.
Could be scheduled at least a couple weeks out.
Yes, right. Definitely, yes. Yeah. So we have another set of bills scheduled for 10:30. House Bill 623 and Senate Bill 218. So we can maybe take a 5-minute break until 10:30 and regroup at that point. Maybe we'll get started with our next subcommittee meeting. I think most of the members are here. Did I give you both those forms? Yeah. Okay.
Is Rick coming with us?
I don't know. I know he had other meetings, so.
To introduce somebody? Yeah, yeah. So say,
Okay, members, this is subcommittee meeting on two bills. The first we will consider is House Bill 623, establishing a teacher candidate loan forgiveness program. And I believe Representative Luno, you had an introduction.
so thank you very much, Mr. Chair, and members of the subcommittee. I bring to you today a student who's a senior at Bishop Brady High School. Her name's Morgan Casey, and she's going to be interning with the Education Dems. Republicans can do their own thing too, but she's an ELO student with us, an informal ELO. She has more credits than anybody could realistically amass towards graduation. But she's very, and I don't mean to disrespect any political side on this, but so seriously, all members of the committee, I hope will get a chance to meet her and ask her questions. And if there's things that you can offer that she may be interested in, please don't hesitate to engage Morgan. She's like I said, it's an informal ELO, and she's really interested and she moves into her college career and afterwards to get involved with public policy. But let me just put you over with Morgan.
Yeah, thank you everyone for having me here today. I'm just excited to learn and see what these meetings are all about.
Do you have any questions before we get started on the process that we have before us today, or anything in general?
I don't have any questions right now, but if I have questions throughout the process, can I ask them during or should I wait till after?
Maybe we will have a break in between the two bills, so
Okay.
That would be a good time.
Okay, thank you.
Great,
Great. Thank you very much, Mr. Chair.
thank you. Okay, so we have the majority of members of this subcommittee here, Representative Balboni, Damon, Cascadden, Myler, and Hall, and myself and Representative Noble, Representative Ford, McDonald, and Lakis do not appear to be here.
Mr. Chair, Balboni has been
Oh, I'm sorry.
spending time with her new grandchild and has come down with a cold. So she said she didn't think she should be here today.
Great, okay. Thank you. We'll get started on House Bill 623. And I believe, Representative Myler, you were the prime sponsor of this. Do you want to kick off the discussion?
Well, yeah, this was brought forth from conversations that we had with the teacher shortage committee. And as we looked at a number of options dealing with assisting to engage new teachers in a way that would allow them to deal with their loan structure that they have in schools as they graduate. And this was one of the things that the Senate, it's a Senate subcommittee. This loan option was an alternative that we looked at for assisting teachers who are beginning. As we know that the those who are between within the 5-year period, there's a high rate of teachers who basically leave the profession. And so this was an attempt to try to deal with the issue of teacher shortage. Rick is on the committee with me to try to deal with a way to help teachers as they start their career and in an attempt to try to provide some loan forgiveness as incentives for them to be there. You'll note that there is an amendment that was presented, Amendment 0221H, that talks about how what the loan forgiveness would be. It would be up to $12,000 over a 4-year, 5-year period. So we would hope that this might be able to be initiated. This program has taken place in several other states. I do not have the number of states that have done something like this, but it has been a very popular program, particularly for areas where there are problems in attracting teachers in rural areas, et cetera, and underperforming schools. And so that's why, Mr. Chair, this was presented in trying to represent the kinds of conversations that we've had in the Teacher Shortage Committee.
Thank you very much. I was wondering, I brought the wrong folder and do not have my original copy of this and the public hearing. But could you go over the amendment again, because the amendment is not listed on the bill details screen.
Yeah, the amendment again tries to focus. It illustrates federal loan, several federal loan programs that are available. It targets rural and underperforming educators, underperforming school educators, as a way to provide incentivizing and helping rural school districts and underserved school districts. And by the way, those are terms that are familiar to the Department of Education. And they're the definition of what they are on lines 23 and 25. And then it basically goes over on the next page that talks about how the teachers would basically be reimbursed, $1,500 the first year, $2,500 the second year, et cetera. And so that's really what the amendment is all about.
Thank you. Further? Yes, Representative Cascade.
Thank you. Just some clarification questions on the amendment. It was written just a little different, and I recognize the term. My question is, because there's a federal teacher loan forgiveness program that teachers access after they complete 5 years, then they're eligible to apply. So would this bill allow anyone within the first 5 years to get loan repayment?
I'm not sure. I'm not sure.
All right, so there is a public service loan forgiveness. There is a teacher loan forgiveness, which again has been quite popular. I've signed a lot of forms on that. Teachers who have worked 5 years now become eligible to access that. There's a Perkins loan, which is not as common, and it's real specific to math, science, ELA, not ELA, but ELL. And then there's state-sponsored school loan forgiveness programs that are called direct loans. So I'm wondering, what group of people are we missing? I'm sure there are, in terms of loan forgiveness. And does this amendment sort of ask them to stay for X number of years?
Yes.
Okay.
Yes. Yeah. And
Is it
the
five?
intent, the intent here is that once a teacher is in one of these defined schools, that they would stay there for that period of time. And I think the other intent is that as they become familiar with the school district, et cetera, that they would even stay subsequent to that loan forgiveness period.
Okay. So it's just a matter of defining how early in their teaching career can they access these
Right, exactly.
loans, okay?
And ask you a question, Representative. Sounds like you mentioned 3 or 4 different programs. And they are all except the state direct loans. Those were federal programs that you were talking about?
Yes. Yes, they are.
With those programs, were they, was there an amount specified? Do you recall in terms of the amount of forgiveness that was
The
provided?
Perkins loan was for teachers who are teaching full-time at a low-income school in certain subjects. And the loan is a certain percentage a year. Says if you're eligible for this program, up to 100% of the loan may be canceled for teaching service in the following increments. So your 15% gets canceled out in first and second years of service, 20% in the third and fourth, and 30% in the fifth. And each amount canceled per year includes the interest that was accrued. So that's Perkins. Perkins, I believe their guidelines are a little bit more stringent than, say, the teacher loan forgiveness. That's the one I'm the most common with. A lot of teachers after 5 years apply for that.
The teacher loan forgiveness is 17,500, up to 17,000.
Up to 17,500, yes. And sometimes it's 5,000. It depends on what area they're teaching in.
If I could just ask Representative Cascadum, when you say what area, do you mean what subject area or what geographic area or both?
It's a combination of both in terms of the Perkins loan. Must be a low income area and subject area, but the teacher forgiveness is primarily in special ed and secondary math and science. Those 3 categories qualifies them for 17,500 in forgiveness. And then eligible teachers qualify for 5,000. So it sounds like that student that is graduating from college and just starting out is the pool of people that probably should be targeted to access loans immediately. Because, I mean, when they come out of college, they get a new job, they gotta find housing. I mean, they're in the poorhouse. But I don't know if that was the intent.
Follow.
Thank you. So 2 questions. Can we get get copies of the amendment? I don't have it either, and I think it would be helpful. And then related to that, in the original bill, if I'm understanding it correctly, it speaks about starting with students who have completed their sophomore year in the university system. So if that's retained in the amendment is part of my question.
Does someone have a copy of the amendment?
I have I've got,
Can we borrow that and have some copies?
so I've got some notes on it.
Oh, okay. Does anyone have a pen?
It's 2002221H.
Oh, okay. Great. Maybe while we're awaiting copies of the amendment, you have further questions or discussion?
Well, I've got a question.
Sure.
Because it says, well, you'll see this on the second page. It refers to a.
This is the amendment you're referring
This is-
to?
yeah.
Okay.
It refers to a commission. And for the life of me, I'm not sure where that came from. So I'm just kind of flagging that.
Okay. Representative Cascade.
Just to add, in part 4 of the amendment, it kind of identifies the reimbursement of eligible education expenses may be provided on behalf of a rural and underperforming school educator. And one of the criteria is they have to have signed a contract with such a school. So if you've got a new grad, again, starting out, when they sign a contract, if you don't want them to sign a contract for 5 years at the onset, because then if they're not a good teacher, you can't not renew them.
No, I think that would be subject to any performance appraisal of an individual. I mean, it's
So
not-
they probably should say
Yeah.
that somewhere, that it says, has a signed contract. If performance evaluation is satisfactory to the district, then that candidate must commit to 5 years, but at any time could be let go within that 5 years.
Either with
That's the risky part.
okay, with the amendment or the original bill, they have an effective date on them. So teachers who maybe started out the year before would not be eligible. Is that the way the language is?
Say that again?
If the loan forgiveness program is effective, let's say July 1, 2024,
Yeah.
right? Someone who was hired in 2023 would not be eligible for the loan forgiveness program?
Good question. Yeah, don't know. Also, I think too, the issue of a new employee is an at-will employee until the 5th year,
Correct.
correct?
Yes.
So, I mean, that would fall under the same kind of aegis of that.
Yes.
Yeah. Okay.
They're not at will, they're still subject to a 1-year teacher's contract, but they're not afforded due process.
Right, exactly. That's, well,
It's more, it's.
Right, right.
At will.
yeah.
Right. There's no reason. You don't need to explain it within
Correct,
5
right.
years, but
Right,
after
but
that, there has to be substantial
That's only
cause.
for a non-renewal, you can't violate their contract.
Right.
Okay.
Yeah.
So you're saying the at-will is at any time? I'm using.
No, it's any time up to 5 years.
I'm using the at-will,
The term at will
maybe it's the
means
wrong term.
that's more of a commercial.
Okay.
Non-public, type of.
So
thing where you-
non-tenured.
Where you can hire and release a person at any time for any reason. The collective bargaining, all teachers are subject to the collective bargaining in the contract. Yeah.
How does the forgiveness work? The loan that the student or the teacher has is through some third-party source or a federal source. Who covers the amount that is being forgiven?
Well, I think the intent here was that it would be a state program.
State program.
Yeah, a state-funded program, yeah.
Thank you, Jen. Right, it looks like on the last section of the amendment, as I think you indicated, has an appropriation for fiscal years 24 and 25 of $1 million and $2 million for the program, and calls on a warrant to be issued to arrive at that money from the Treasury.
Right.
What was that amount again, please?
It was 1 million in 2020, year ending 2020, June 30th, 2024, and 2 million ending June 30th, 2025. So if Representative, you go ahead.
I was just reflecting on your inquiry, Representative Cordelli, about, I think, essentially saying who's paying. Correct me if I'm not paraphrasing accurately.
Yes.
Line 35 and going forward from there in the amendment speaks about the department reimbursing public schools, with the public schools submitting to the department verification of eligible loan repayments, and then the department reimbursing the public school for that cost. So I assume the department is the Department of Education.
Right. Thank you.
And if I may,
Sure.
so relative to your question before we had the amendment in front of us, I mean, I would appreciate some discussion about the question of making it retroactive to at least some degree. I realize that changes the costs. But the need is already there. And so if this, I mean, right now the amendment says effective July 1st, 2023, which is obviously not going to be the effective date. Well, I don't know, that would be retroactive. Can we do that? So I guess if I'm putting this as a question, how would retroactive work? How would we
Good question.
say that?
Yeah, I don't know that.
You know, the appropriations are for 2024 and 2025.
Yeah.
So we have to fix that.
If I could ask Representative Ladd, in terms of the teacher shortage committee, how does this fit in with what's been going on with that committee?
I think this parallels a lot of the discussion which we've had on the teacher shortage committee. Sometimes I look at the amendment here and I don't think it's wide enough in scope, but we're talking about rural locations or underperforming areas based upon the NAEP. I don't know if that's the proper tool to use. But when we're talking about a area like a Manchester, which is in dire need of teachers in certain shortage areas. So, you know, the whole concept here, I agree that we got to do something to keeping and attracting folks into certain areas in the state where we have shortages. But I think we have shortages of special ed teachers everywhere. Not just, you know, in the Manchester, but you might have them out in the wealthier property, I hate to use rich, but well-endowed communities. So, and of course, we do know that the shortages primarily they're in communities which can get the good teachers from surrounding areas come in because we pay more based on our negotiated agreement. So I concur with much of what I see. I'm reading this, trying to grab a hold of it now for the, you know, probably the second time or third time. And I'm just trying to get a good fix on it. You know, 20 enrolled students per square mile, that's kind of a general term we use in a lot of language like this. Is New Hampshire the same as, some others, states? And using the NAEP for grades 4, 8, and 11, we also give our statewide assessment here. We also have graduation rates too, which we could use as a determiner. But I support the scope of this. In the intent of the bill.
It needs
I just need a little more time to read
It
it.
needs some work.
Yeah, but I think we can't delay too long on it.
Yeah.
I think it needs some work, and I think that would be the position of those that are on the teacher shortage committee as well.
President
And
Cascade.
we have, if I may,
Yeah.
we do have a teacher shortage committee coming up next Monday, I think. And I'm not sure they've even seen this. We've talked about the concept.
Myler, that we bring this to that and get it on the docket for discussion at that meeting, so we can go through it and you can have another set of eyes looking at, including some Senate eyes.
Yeah, good. I think we'll do that. I'll do that, yeah.
And I think for retention, I think it would be a carrot for teachers graduating from college. If the salary is not as high in one district as another, but yet there's an opportunity for loan repayment, I think that would be a good thing. I think it's that pool of people that are struggling to stay in the field because they can't afford it. And also language should be in there so that it is up to the district in terms of pending evaluation process.
On this whole issue of teacher shortage, we've looked at this. I'm introducing a mentoring bill that's also for this session. I also heard the other day, I was talking with Representative Woodcock, and he was saying that while he was in Texas with his new grandbaby, he read a story of Houston schools. The school district is actually building housing for teachers, a huge complex that they're now developing to attract teachers to come to teach there and have reduced housing costs for them. So there are a number of different things that are we haven't gotten to the housing issue here, although there is childcare is another issue. Although there is we did discover that in Littleton that there is housing. You may be familiar with that.
Not very, but I'm aware of housing.
There was a housing issue there where they were providing housing for teachers and interns, actually.
Yes.
To try to attract teachers because of the rural nature of the particular school district. So this is just one of a variety of different alternatives that we're looking at.
Glenn, can I interject for a second? I'm also concerned that we're talking about, I believe, the university system in New Hampshire. We talk about university system in the last line of we also talk about New Hampshire. But we're seeing fewer graduates coming out of the Department of Education at UNH than we have in previous years. Not just because of demographic either. And so we're picking up teachers that are coming out of SNU. We're teaching out teachers coming out, and we want to retain these residents in our state, teaching our state. And I'm not quite so concerned whether they're a graduate of Keene, Plymouth, or UNH. I think we ought to be trying to attract and keep our New Hampshire students that are deciding to be teachers in our state, regardless of where that degree is from. We're employing more teachers in the state now, of course, that are from out-of-state institutions than we are from our own in-state institutions. So to be really effective, we need to think of where's the well this money's coming from, but also trying to get more students participating in this program.
Yes.
Thank you. I echo Representative Ladd in regards to looking at this more broadly than the university system, SNU, Colby Sawyer College, any number of institutions that are educating teachers, a lot of them people who are residents in New Hampshire who grew up here and then they leave to teach elsewhere. This could make it more attractive for people to stay. I'm also wondering if the consideration of rural and underperforming, what Representative Ladd was noting, that you might be in a non-rural area but be an underperforming school and, for example, need special educators. What if instead of it saying rural and underperforming, it was rural or underperforming, and there's more than one place where that distinction would need to be made? So in other words, a teacher would qualify for loan forgiveness if they were either in the rural district or the underperforming district, but it didn't have to be both. Just a thought.
Representative Cascadden.
Thank you. I have a question on part 8. I want to make sure that it would be line number 35, 36 on page 2. It mentions that the department will reimburse the public school for qualifying loan repayments. Does that mean that the public school district will be giving the money to the teacher and the state will reimburse them? Why can we?
So it sounds like, yeah.
So that means the public school has to budget for that money ahead of time. And who knows what could happen. I'm concerned about adding that dollar amount to a school budget that's lean. And could we skip that step completely so that the district verifies and applies to the state? I just don't.
That's a good point.
I don't like coming
You know
up
what
with
we
the
did
money.
with dual and concurrent enrollment? The money was going to the district, but now we send it directly to the community college system and we take out that middleman.
Yeah,
It's good. It's a good
pay
point.
it off. Yeah.
And it already has in section 5, line 22, that the educators are applying to the department for this program. So why does the school district even need to get involved?
Right. Other than verifying should be their only commitment.
Good.
I think one concern I have is the concept of loan forgiveness and a need in terms of employment. We've been having a lot of conversations in my county about the nursing shortage and how it's impacting our county nursing home and the costs of bringing in agency staff. And articles all the time about the nursing shortage. In other industries I've read about in the state as well that are having shortages, but we have lowest unemployment rate, in the country, I think, or one of the top 2. The whole subject of loan forgiveness and, where does it start, where does it end, is a general concern of mine also. Representative McDonald.
Along those lines, I had a question. I'm drawing your attention to page 3, specifically lines 9 through 11, so towards the end, and on the amending language. And the amendment grants the governor the ability to draw additional sums of money from the treasury if necessary. Is that power able to be checked by the executive council, or is that power just granted to the governor?
I don't believe it goes through the executive council.
Well, this has been good. I appreciate this. Let Rick and I take this to the group next Monday and get further feedback on that. And then I made some notes here. And I have got some questions on this too. So we can set another meeting and I'll bring back something.
Representative Cordelli?
Yeah.
I also feel that we got to get a better grip on understanding of where the shortages may be. as you recall, several years ago, about a year ago, we were asking for information from the districts in terms of what are your shortages. The superintendent over there, we only got 20% return. We got a high, according to Mr. Appleby, right now, up around 56% return. So we're not getting a good return from the field on this information we need to make these decisions. We do know, though, the Teacher Shortage Committee does know that there were shortages before COVID in certain subject areas. Unlike maybe in nursing as well, but I'll tell you right now, according to what I heard at the higher education meeting the other day with the trustees, is we're putting out enough nurses now that we're in a little bit of an uptick on it. Now, it may not keep going like that, but compared to where we are with the teachers, there is still this downtick. But I'd like to see some real good information coming in from the districts as to where these specific shortages are in these teaching areas. We knew beforehand we had special ed background issues. We knew we had issues dealing with the sciences. We couldn't find them, especially in the rural areas. So I'd encourage DOE to try and get a better return on the survey this year. And I know that I spoke with even Steve just this weekend, and they're trying to work on that. But we need to get that information too for this teacher shortage meeting, which we're going to have here in a week.
Representative Hall?
Thank you. I'm wondering about, let's say on page 2, lines 27 to 29. What about the teacher who's a great teacher, but has been faced with reduction in force? So they've been RIFed in their school district. Does that mean that now they're not going to be eligible if they go get a job at a different school or a different school district, even though they went to a rural or underperforming school? But if they were RIFed, they had and they're a great teacher. But you know what? Our numbers are down and we don't need that science teacher anymore. So now they've got to go somewhere else and they're out.
Yes.
The other piece to think about when you do go to committee, I'm finding in the ads north of the notch is administrative positions. I mean, there are assistant administrative positions. Just look at the superintendent level, there's a ton of interims. But I'm finding that building level administrators were not traditionally on that critical shortage list that came out, but now you're seeing that come up. So if you've got somebody who was in the field, went back to school and got certified, they may have loans. I don't know if that's a pool of people you want to add to this or not. I mean, I'm open to either way, but when you're talking about critical shortage, it's hard to get good administrators to do the job.
Yeah, I think our study was primarily we had a number of people who came to us, nurses being one, paras being another, and I think the committee said no, we need to focus just on teachers, and that really is the scope of it. Yeah.
But according to the law, a principal is a teacher is a principal. Or the principal is a teacher. Principal is a teacher. For certification, yeah.
Okay, so I think the consensus is that we will have a follow-up meeting at some point soon after the teacher shortage committee and get their input and possibly some amending language after that.
I appreciate the feedback. This has been good.
Yeah.
Thank you very much.
Yes, Representative Damon.
Thank you. Just one more. Could we ask the DOE to provide us some maybe list of communities that are rural by the definition here of, what is it, less than 20 enrolled students per square mile? And similarly, which ones are considered underperforming?
Yep.
We can make that request to the department, yes.
See what we get.
Yeah.
Thank you.
So I think that will end our time on House Bill 623. And we have ahead of us Senate Bill 218. Should we move right into that? get out when we can.
Yeah, get that.
Senate Bill 218 establishes an early educator professional development grant. And
Can we have Brian Hawkins up here on that one, please? I know Brian has talked with Steve Appleby, and I've talked with not Steve, but not on this topic, and he may have some information on mentoring that we may want to hear from the department.
sure.
Thank you, Mr. Chairman. For the record, Brian Hawkins from NEA New Hampshire. So I did reach out to Mr. Appleby at the department to see if he had any suggestions to address some of the concerns that the committee made back in the spring. And so, and I know he couldn't be here today, so because it did sound like that he may have some suggested language. We did work with Senator Fenton on this bill, and the idea being that those early years that an educator is in a school are, as the shortage committee also heard, are the most critical, and to make sure that there are plans in place at the school district level, and then as well as assistance for those school districts that want to put in place a mentoring plan, and that was the idea behind the grant. So I'm happy to answer further questions. If I know there was some question about from the retained discussion about who is an early educator, and I guess I would point to the first 3 years that in Z1 line 7, the idea behind this is the people who are early in their career in education, or it may be their first year in a new school district, or in a first year in a new role, because those are also very important times for an educator to have that additional help.
Yes, Representative.
It's my understanding that the Title II funds would also cover a mentoring program.
Title II, yes.
So-
Title II can be used for that. Yeah.
Okay. So I think I'm confused why this is even needed if that's covered. Because from what I understand, that money is not being spent down. And we would have to spend this state money before we could even get into the Title II funds.
My recollection from the hearing, and again, there was no mention of this in the Senate phase, but my recollection from the hearing from the department was they were not sure as to whether that was the case or not. That was presented to the committee, but that was going to be confirmed. And so I'm probably not in a position to, say whether that's true or not. I'd point to the folks who handle the Title II. But that was my recollection from April or May, whenever it was.
Your recollection was that the state grant funds would have to be utilized prior to Title II kicking in.
That from what I recall, there was the concern raised by the department was that any state or local funds had to be spent down prior to accessing Title II funds, but that was going to be followed up on. Yes, thank you for the clarification. Yeah.
Thank you. Representative Cascade.
Thank you. Yes, again, I think I raised the question earlier about the term early educator. My perception would be a certification of newborn to grade 3 or preschool or early education. And it sounds like it's anyone that's new to the profession. Is that what it's intended for?
Yeah, I think thank you for the question. The intent being new to the, sort of the, in the requirement for the local master plan to include a professional development in the first part of the bill. The intent was the definition of early educator to meet one of those three descriptions in lines 7, 8, and 9. Yes, not that they're in kindergarten or early elementary.
Can I? So this is intended to be a teacher mentor or induction program?
This is intended to be, I suppose, a mentoring program, but that it allows for the district to come up with that plan and submit that to the department. And I think the description in lines 5 and 6, I think, speak to that about articulate that plan has to articulate what are the professional learning goals and descriptions of the development activities the district will use to orient a new educator.
As a follow-up? Yes. That seems to me that it's in direct conflict of Title II Part A, which is preparing, training, recruiting high-quality teachers and principals. And you have to prove that your mentoring program has to meet your district's goals and objectives in your master plan. And I just worry about those federal funds as opposed to the state fund, because the federal funds are allocations. So people, they need to submit sort of an application or a justification to be able to use it, but they don't actually need to apply for it. It's not competitive. So I'm not sure what this program would do that's over and above that, because you can have a very robust mentor and induction program with those federal funds. When I looked up, there are very few, every town gets an allocation.
Right.
Except for those, I believe, that don't actually have a school building in them. So I'd want to know, what does this do that's different than that? Or is it more money to do more? And I don't know why we need more if it already exists. Do you know?
Sure. So I think the idea was we had heard that there were districts out there that were not necessarily using their Title II funds for this purpose, and the idea would be as sort of a carrot that this would be something that they could supplement a program and incentivize school districts to prioritize this as a program for their early educators. And I think at the end of the day, so much of it comes down to, as you all know, what are we going to spend, whether it's state funds or federal funds, what are we spending them on? And the resources dedicated to those early educators can be one of those areas that falls through the cracks when you're making difficult decisions about what to spend your dollars on, including your Title II money.
Right.
Yeah.
Mr. Damon?
So if you would just clarify for me from what you just said, am I correctly understanding that districts might be spending their Title II money on other purposes and therefore would need what this bill proposes to do to provide the new educator mentoring?
Other purposes, or even that there may be unspent Title II funds out there that had they been used potentially in conjunction with this, could have been put to use to help the folks that we're talking about.
Thank you.
Aren't professional, when I receive Title II dollars, we usually use those dollars for professional development in the area, for example, like the reading information that Representative Cordelli's been bringing forward K through 3. or we did it for mathematics, or we did it for some other area of our curriculum and instruction. I see this bill here, primarily here, I think Representative Damon, you just said new teacher mentoring. And so orienting that teacher to what we do within the system that they're now going to work within. So we may have a reading program there, which we have to get that teacher up to speed to what we're doing there. But professional development, I see more in regard to the total scope of what the larger picture for that school or school district. But these people coming in that we have to orient and get on task of how we do things here in town X, that's where I see this mentoring program being of help and assistance to us.
Representative Myler, I believe you mentioned that you had a bill coming forward next session on mentoring.
Yeah, it's being developed.
Okay. In development, in progress. Great. Where do we go with this? It seems like there are questions about the use of the funds and Title II funds.
I'd like to have an accounting on that from the department in terms of how the our Title II monies have been used and what type of, we did get a sheet on that, as you may recall. There was a balance left over. Why is it not being used? Is a question that we should have, before we start generating another pot of money. If we have the funds available, let's use them. Maybe for this area, I don't know, but we do need to have an accounting from the department on where we stand on that for the year we just finished.
I think that's a good suggestion. Any further suggestions, or shall we piggyback this with future subcommittee meeting also and get that information from the department as well? I think that's the direction that I'm seeing by the nodding of the head. So we will schedule future subcommittee meeting for all four of the ones that we heard today, and gather some information in the meantime, both from the teacher shortage committee and from the department. Representative Ladd?
Are there any definitions or policy statements which maybe the School Boards Association has on what is mentoring? Is there, we use mentoring sometimes here broadly for so many different things in professional development. Is there a consensus amongst the school districts as far as what they see as a mentor as? I don't know.
I guess
I don't know if there's any school board policy on it or not.
Yeah.
There probably isn't.
I see a no coming from the audience there. So looks like we can do some scheduling work and some work in gathering more information and looking at language, and come back at some point in October to finish this up. All right. So thank you very much for everyone in the meantime. And Morgan, did you have any questions before we break that you'd like to ask of us? If you want to.
Representative Ladd brought up this point, but just what is the further distinction between the orientation and kind of initiation into a new school district versus the personal development? Because I was kind of under the impression also that personal development was kind of going above and beyond and developing a specific set of skills that teachers are working towards versus just getting acclimated to a new teaching profession, location, etc.
I think personal development, for example, as a school principal for all those years, I had the responsibility for going in and supervising and making recommendations whether a teacher would, at that time be tenured, not be tenured. And you do another number of observations. And you may come out at the end of the observation saying, this teacher needs improvement in this area. One of the times when I was back here in the state working over in Rumford, in Maine, in Rumford, I recommended that teacher go back to the University of Maine at Farmington and take a course in language arts and teaching of. And that person did that. We helped, because it was a recommendation made by the district, we helped with that. So that was a individual personal need based upon observations done by the administrator in the school. I don't consider that necessarily mentoring. That's just my job to make sure that we have somebody qualified at the level we want within the classroom. And you're giving every best shot you can where you see there is room for improvement. But I saw professional development more on a larger scope of what was good for the whole as far as our moving forward with curriculum development.
Thank you for that clarification.
Representative Hall, did you?
A little bit further on the mentoring, I do think it's the works of the school. You got a new person coming in, your specials teachers are using competency-based grading, your regular teachers are using A, B, C, D, and you're trying to, this person's coming in and need to know the rules of your school. Whereas professional development, as Representative Ladd mentioned, I see that as a whole school initiative. We're going to, I can't even think of an initiative right now, but you're going to take it on. So the whole school has to learn about this new program that they're going to do or the new philosophy or whatever. But yeah, I see mentoring as an individual. I know in our school, the mentoring program was for those new teachers that came in, and they would look for a seasoned person. You had to be there, let's say 5 years, to be the mentor and to be paid. Sometimes you have them and they're not paid. Sometimes you have them and you are paid. And then sometimes people get mad because they mentor, but they don't get paid because it's just their nature to mentor their colleague. So it's kind of I do see them very different.
Thank you very much, everybody, and be in touch. Yeah, is he missing the notification that hearing or sitting out, or I'll reach out to him. I'll reach out to him. Yeah. So both of these, they didn't show up. They didn't show up. And he doesn't show up. And another that doesn't show up, we're gonna show up. But it's, yeah. Right. See, I was able to stand in if they want to stay.